G'day everyone, and welcome to the third of my 2-hour law courses. I'm really grateful for the enthusiastic support the previous two videos have received, and I've taken notice of the number of people asking for a 2-hour constitutional law course. I'm terribly sorry it's taken me all these months to get around to it, but I have done it in the end. Your wish is my command. It seems like a lot of you find constitutional law to be really difficult to get your head around, and I think in some ways this may be a scheduling issue. You see, most universities throw the Constitution at you in your first year. And they really kind of have to, because a lot of our legal system makes no sense until you understand constitutional law. And yet, because some of the material really is quite complicated, it can be hard for a first-year student to handle. You'll also notice that constitutional law builds very much on the material that you should have covered in your Introduction to Law course, or whatever title your university gives to its basic entry-level 101 law subject. Now, during that subject, you should have covered a range of things about, for instance, our parliamentary system and our system of courts, and in general terms, how the Constitution binds them all together. Oftentimes, I find that when students are struggling to grasp constitutional law, it's really because some of those basics aren't there. If you find that you start to struggle in that way, well, I'm going to provide you with some links in the description of this video to some of my own Introduction to Law videos, which I did a couple of years ago when I was working at a university. Those videos will help you to cover that material again very briefly. It'll be worth the investment of an extra hour or so, because without that basic stuff under your belt, it'll be very difficult to wrap your head around constitutional law. With this video, I'm hoping to give you the general architecture so you can fill in the gaps with your own more detailed study. On the other hand, if you're not a law student, perhaps you're a political science student or just an interested citizen, you might find that this video is enough, or that it points you towards the specific questions you're interested in. I promise you though, constitutional law really isn't such heavy going, and it really does have its interesting aspects. I sure hope you enjoy the next couple of hours and that they make a bunch of sense to you. I'll tell you what though, I'm a bit intimidated by the stopwatch on this one. Still, let's have a go. Start the clock. We're going to begin at the beginning by asking, what is a constitution anyway? Surprising how often people forget to even ask this. Well, most countries have a constitution, and a national constitution really has two functions. It establishes the existence of the nation, and it establishes the fundamental rules by which power is used in that society. Not all constitutions are actually written down in one document, but Australia's is. And finally, Australia's constitution also serves as the record of a deal made by the 6 founding states when they came together in the late 19th century. Let's have a look at each of those 4 aspects of the Australian Constitution. First and foremost, the Constitution actually establishes the fact that a nation exists. In our Constitution, this is done in 2 ways. First, the preamble to the Constitution of the Australia Act 1900 Imperial states, "The people of New South Wales, Victoria, South Australia, Queensland and Tasmania, humbly relying on the blessing of Almighty God, have agreed to unite in one indissoluble federal commonwealth under the crown of the United Kingdom of Great Britain and Ireland." Do you notice something about this though? Where's Western Australia? Well, the Western Australians hadn't actually agreed to join the Commonwealth at that point, but that was fixed up in Section 3 of the same Act, which gave Queen Victoria the power to declare by proclamation that the people of New South Wales, Victoria, South Australia, Queensland and Tasmania, and also if Her Majesty is satisfied that the people of Western Australia have agreed thereto of Western Australia, shall be united in a federal commonwealth under the name of the Commonwealth of Australia. The Queen then made a proclamation that all of the states, including Western Australia, would be united in the Commonwealth on the 1st of January 1901. The second thing the Constitution does is that it establishes the fundamental rules by which power is used. In other words, it sets out what the basic institutions of power are going to be and how they're going to be able to do things like make laws and raise taxes and fight wars and manage the country. So any government, any politician, any public servant, even the Queen herself, can only use any sort of public power if they can point to the bit of the Constitution that gives them that power. And if they make laws or decisions which are outside those constitutional boundaries, well, that exercise of power will be invalid. And really, the rest of our constitutional law course falls out of that basic statement. I mean, really, the reason we're interested in the Constitution as law students and as lawyers is because the Constitution says what laws can be made and how they have to be made and how governments can exercise power and how courts have to operate. And constitutional law is the study of all these basic underlying rules. That's why we learn it. It's really important to try to keep this in mind as we go through the rest of the material. Now, Australia has a written constitution. Most countries in the world do. However, a number of countries, including some that are very close to us, do not have one single constitutional document that they can point to and say, there is the Constitution. The United Kingdom, for instance, doesn't have a written constitution. The UK Constitution emerges from a bunch of laws and conventions going back over hundreds of years, including everything from Magna Carta to the Bill of Rights 1688 to the unwritten conventions described by a very influential author named Albert Dicey. Similarly, New Zealand doesn't have a single constitution. In fact, our Kiwi friends didn't even have a Constitution Act until 1986, and that's not a full constitution. They also have other important documents such as the Treaty of Waitangi, which sets limits on the use of power. In Australia, while we do continue to observe many of the conventions handed down to us from the United Kingdom, our Constitution is a single written document. There are some other important pieces of legislation you'll need to know, particularly the Statute of Westminster and the Australia Acts, and of course our understanding of the Constitution has been sharpened by many High Court decisions. But ultimately in Australia, the Constitution on its own is the Constitution. The last really basic principle I want to point out is that the Australian Constitution essentially represents a deal. You see, before there was an Australia, there were 7 independent colonies: Queensland, New South Wales, Victoria, Tasmania, South Australia, Western Australia, and New Zealand. And during the latter part of the 19th century, people like Sir Henry Parkes and Sir Samuel Griffiths led a great enthusiasm for the idea of those states coming together. And by the final decade of the 19th century, the federation movement was well underway. The New Zealanders went their own way, and the Western Australians very nearly went their own way. But ultimately, the 6 colonies without New Zealand decided to federate. What does that mean? Well, it means that instead of having just one parliament and one government over all the land, the state governments wanted to stay in existence and wanted to continue to run everything in their state. But they wanted to give the Commonwealth a limited amount of power to deal with those things that made sense on a broader national level. So they did a deal. The Constitution records the agreement between the 6 states about what powers they were prepared to give to the new Commonwealth and about how they wanted that Commonwealth to use that power. At its heart, it's important to remember that our Constitution was never some grand statement of principle. It started out as a political deal between the 6 states to create a Commonwealth government for the convenience of those states. Let's have a look at the fundamental architecture of the Constitution. At its broadest, what does that deal between the states, what does that deal look like? Well, the first thing to note, and this is really confusing at first, is that Australia's Constitution is not actually a piece of Australian legislation at all. It's a British piece of legislation, which was passed in 1900 in the Imperial Parliament. So that is the House of Commons and the House of Lords in the UK. So hang on, how does that work? Well, none of the 6 states were independent states. They were all colonies, which meant they were possessions of the United Kingdom. So to become a separate independent nation, they had to find a way to sever that line of possession. Our American friends, of course, did so by making a declaration of independence and fighting a war. Australia's method was not nearly so exciting. Essentially, the colonies went to Queen Victoria and said, "We'd like to keep you as our queen, but instead of being possessions of Great Britain, we'd like to federate and become a single nation, Australia, with you as our head of state." And so the Constitution of Australia Act 1900 was essentially the Parliament in London saying, "Okay, we agree to the formation of Australia as a separate state. You, the 6 colonies, have told us what you'd like your constitution to look like. And so here it is, the Constitution of Australia Act. Now, Section 9 of that Act is your brand new constitution. Go for gold." And so without a shot being fired, other than maybe a ceremonial cannon or two, Australia was born as an independent nation. The thing is, of course, there were still a few areas of crossover. A few areas in which the Australian government was not absolutely independent from the United Kingdom. And that really didn't bother the founders very much. I mean, none of them really hated the UK. They all considered themselves to be essentially British, and nobody had been shooting at anyone. And so while from 1901 we were effectively independent, a few small areas of overlap remained. The first important one was that the UK Parliament still retained, in theory, the capacity to make laws for Australia. I mean, after all, they could hardly make our Constitution Act if they lacked the power to make laws for Australia, right? So in 1931, the UK Parliament passed the Statute of Westminster Act 1931, which gave up the power to make legislation for the Dominions, including Australia, without the agreement of the Commonwealth Parliament. Seriously though, the Australian government was not terribly worried about this issue. The Statute of Westminster didn't even take effect in Australia until the Commonwealth passed the Statute of Westminster Adoption Act in 1942. 11 years later. Still, overlaps remained. I mean, for one thing, were we really independent if the UK could still make laws for Australia even by consent? And it was also still possible at that stage to appeal from the High Court of Australia to the Privy Council, a court in the UK. So finally, these overlaps were done away with by the Australia Acts 1986, which were two acts passed simultaneously in Australia and the United Kingdom. So from 1986 at the very latest, we can say that Australia's constitutional system has been absolutely independent. Now, a few times already in this video, you've heard me talking about power and about how the Constitution regulates the use of power. But what do we mean by power exactly? Well, at its heart, power is the ability to make other people or other things do what you want. If you can make them do what you want, you have power. Lawyers and political scientists divide power up into three categories, which we call the three estates of power. The first estate of power is the power to make rules. We call this legislative power. If we were running a football game, legislative power would be invested in the Laws Committee, which decides on the rules of the game and any changes to those rules. At a national level, legislative power is the power to make laws, and it's a power which is given to the Parliament. So ultimately, nobody can use public power to make laws in our society except for the Parliament, or some other body which has the Parliament's approval to do so. The second estate of power is the power to carry the rules out. We call this executive power. In a football game, a range of different officials have various executive powers. The groundskeeper who marks the lines on the field is using executive power. The attendant at the interchange gate is using executive power. The timekeeper is using executive power. The official scorer is using executive power. Can you see they're all carrying out the rules that were originally made by that Laws Committee? Well, at a national level, the executive power is given to the Prime Minister, the ministers, and the public service departments which serve them. So everyone from the bean counters in the Department of the Treasury to the soldiers in the Army, which falls within our Department of Defence. They're all using executive power. The third estate of power is the power to decide on disputes about the rules. We call this judicial power. In a football game, judicial power is mostly given to the umpires. So when there's a dispute about a rule, for instance, whether a player is entitled to a free kick, it's the umpires who decide, and their decision is final. At a national level, judicial power is given to the courts. Whenever there's a dispute about the law, the disputing parties place that dispute before the courts and they argue their case, and the court decides who's correct. Now, if you open up your Australian Constitution, what do you see? Chapter 1 is called the Legislature, and it outlines the rules for our Parliament and its processes for making laws. Chapter 2 is called the Executive Government, and it outlines the rules for those carrying our laws into effect. And Chapter 3 is called the Judicature, and it outlines the rules for the use of judicial power of the Commonwealth. So the three estates of power are that clearly represented in the Constitution. Now, there's a theory called the separation of powers. And that theory suggests that those three estates of power, the legislature, the executive, and the judiciary, should be kept completely separate. so that each of them can act as a balance on the others. The theory is that if anyone gets their hands on two or more of those estates of power, they will potentially become a tyrant. Some of the world's most significant republics, nations like the United States of America and the Republic of France, have systems based on this separation. Although you wouldn't know it when you see the political process the Americans use for selecting their Supreme Court judges. In the UK, and as a result in Australia, we don't actually follow the theory of separation of powers. We do like to keep our courts independent from the other two branches, but there are two important ways in which we ignore the separation of powers. The first is theoretical, and the second is much more practical. First, from a theoretical perspective, all three estates of power in Australia are actually held by the Crown. Her Majesty the Queen, through the Governor-General, has a legislative function by signing laws into effect, and an executive function as the titular head of the executive, and a judicial function because the courts are institutions of the Crown. So, for instance, every lawyer, when they become a lawyer, makes an oath or affirmation of their allegiance to the Queen. In reality, of course, Her Majesty is a constitutional monarch, so the Crown's powers are not exercised by the Queen or the Governor-General, but rather they're exercised by the institutions described in the Constitution. Second, and far more importantly in Australia, the leadership of the executive government, that is the Prime Minister and the ministers, well, they're all drawn from the Parliament. The Prime Minister is by definition the person in the Parliament who has the support of a majority of members of the House of Representatives. Voters don't directly elect the Prime Minister. Voters elect their parliamentarians, and those parliamentarians elect the Prime Minister. In return, though, the Prime Minister and the government must respond to questions and criticisms from the Parliament. This system, where the executive and the legislature overlap, is called the Westminster system of responsible government. Let's take a look at how it works by diving into Chapter 1 of the Constitution. Section 1 of the Constitution establishes the Parliament, which consists of the Queen and two houses of Parliament, the Senate and the House of Representatives. Because the Parliament has two houses, we refer to it as a bicameral Parliament. This is yet another constitutional inheritance from the United Kingdom, which has a bicameral Parliament. However, the upper house in the United Kingdom, which is called the House of Lords, is populated by members who are appointed, not elected. When the 6 states made the deal which created the Australian Constitution, they opted to have both houses elected. And so they looked to the United States Senate as a model for what became the Australian Senate. The Parliament is called together and prorogued or dismissed for elections by the Governor-General. That's in Section 5. The Constitution makes it sound like the Governor-General gets to choose this on their own, but in reality there's a strong convention that the Governor-General calls the Parliament and prorogues the Parliament on the advice of the Prime Minister. So the Governor-General has the formal power, but in reality the Prime Minister has the real call. The Parliament has to sit at least once a year. Well, this is important because the government could hardly be responsible to the Parliament if the Parliament never sat. The lower house of Parliament is called the House of Representatives. It has a number of important features. First, it's based on what are called single-member electorates. So Australia is split up into a certain number of electoral divisions, currently 150. And each of those electoral divisions returns one member of Parliament, who's the representative of that individual electoral division. The members each serve terms of a maximum of 3 years before they must seek re-election. Perhaps the most interesting thing about the House of Representatives is how those electoral divisions are arranged. You see, each state gets a number of electoral divisions based on its overall proportion of the Australian population. So New South Wales, which has roughly a third of Australia's population, has 50 seats. Tasmania, on the other hand, has only 2% of Australia's population, so it has far fewer seats. In fact, it has the minimum number of seats allowable, just 5. In this way, each member of the House of Representatives represents roughly the same number of voters, and so each voter has roughly the same say in their political presentation, whether they're in Perth or Proserpine or Penrith. Interestingly, the Constitution does not prescribe the exact method of voting, so long as the method that's used still adds up to a House of Representatives, quote, directly chosen by the people of the Commonwealth, end quote, in each electoral division. The upper house of Parliament is called the Senate. Now, the Senate really was crucial to the deal between the states, which allowed federation to happen in the first place. So imagine you were representing one of the small states, say Tasmania, South Australia, or Western Australia, at the Federation Convention. You're doing the federal deal. Well, you'd look at the proposed House of Representatives and say, hang on, the people of our states are going to be overwhelmed by the opinions of those in New South Wales. If they get 50 members and we get just 5, we don't want to go from being a colony ruled by London to being a colony ruled by Sydney. Well, the Senate was the answer. It was based on the United States Senate, which has 2 members from each of the 50 United States. So tiny little Wyoming with 500,000 people has 2 senators, just the same as California, which has over 38 million. In Australia, the decision was to have a Senate which was approximately half the size of the House of Representatives, but with each state having an equal number of senators. So the Senate is sometimes referred to as the State's House. At present, each state has 12 senators, and they serve for a maximum of 6 years each before they face re-election. The next thing you need to understand about senators is that they do not represent single-member electorates. Instead, all 12 senators represent their entire state, and the entire state votes as one electorate to choose its senators. What about the territories, though? Well, for many years, they were not represented in the Senate because they weren't part of a state. But that seems unfair that people in states get to choose senators and people in territories don't. I mean, it undermines the whole concept of an equal democracy. In the 1970s, legislation was introduced to provide 2 senators each for the Northern Territory and the Australian Capital Territory. This legislation was immediately challenged by Western Australia and Queensland, but the High Court found that it was in fact within the power of the Parliament to provide senators for the territories. So those are our 2 houses of Parliament. There are 2 more important questions I want to tackle before we move on. Who gets to sit in Parliament and who gets to vote for the Parliament? Now, the Constitution itself doesn't prescribe qualifications you must meet to be in Parliament, but it does empower the Parliament to set such qualifications. At present, in Australia, to be a parliamentarian or to stand for Parliament, a person must be an Australian citizen, they must be aged at least 18 years of age, and they must be eligible to vote. However, the Constitution does set out a number of factors which disqualify a person from sitting in Parliament. These include certain criminal offences, bankruptcy, a conflict of financial interests with the Commonwealth, and being a foreign citizen or under some allegiance to a foreign nation. This last one has become very interesting in recent years, with an absolute slew of senators and members of the House of Representatives having to resign after learning that due to technical citizenship rules, they actually held citizenship rights in other countries. The Constitution also doesn't establish specific rules for qualifying to vote. Those are established in the Commonwealth Electoral Act. Basically, you have to be 18 years of age, a citizen, on the electoral roll, and not serving a sentence for a serious criminal offence. What the Constitution does say, however, about electors is that the Commonwealth was not allowed to change the law to deprive any individual person of the vote if they had the vote on the date of federation. So in South Australia and Western Australia, women already had the vote at the start of federation. So in those states, and only in those states, women voted in the first Commonwealth election. In South Australia and Tasmania, but only South Australia and Tasmania, Indigenous Australians had the vote. So in those states, Indigenous people could vote in the first election. In the other states, though, it took a couple more years for women to get the vote, and another half a century for Indigenous people to get the vote. So now we have our Commonwealth Parliament. The next question is, what can it do? If we were talking about the Parliament of a unitary nation, like, say, New Zealand, so a nation which isn't a federation, well, then this question wouldn't even make sense. The answer would be that Parliament can make laws about anything, obviously. A Parliament with the power to make laws on any topic has what we call plenary legislative authority. But the Commonwealth Parliament doesn't have plenary legislative authority, does it? Remember, when the 6 states came together to do a deal and they created the Commonwealth, none of them was prepared to give up all their power and authority. They all wanted to retain their own state parliaments to deal with more local matters, and they wanted to limit the Commonwealth Parliament to issues that should really be dealt with at a national level. They did this by enumerating or listing the powers of the Commonwealth Parliament. The states then retained what we call residual power to legislate on everything else. By this method, the intention was to limit as far as possible the powers of the Commonwealth and the potential for overlaps and conflicts between the Commonwealth and state laws. The majority of the Commonwealth legislative powers are listed in one long section of the Constitution, a section which all good law students come to know very well, Section 51. We're going to spend a lot of time in this lecture looking at some of its key provisions. We're going to start with Section 51, subsection 1, which is called the Trade and Commerce Power. We're going to go into it in some detail, just to show you how this constitutional enumerated power process works. Section 51, subsection 1, gives the Commonwealth the power to make laws with respect to trade and commerce with other countries and among the states. This was a very important power during the first 6 or 7 decades of federation, when industries were still extremely heavily regulated by the government, before the Australian economy was opened up to free trade in the 1980s, and certainly before the decline of the Australian manufacturing sector from the 1960s through to the present. It's still an important constitutional power in some industries. The words trade and commerce do not have any specific legal meaning. The words simply have the meaning which any ordinary person would give them, or perhaps more importantly, the meaning which any person involved in trade or commerce would give them. Trade and commerce does, however, include incidental or ancillary activities such as manufacturing, production, environmental impacts, and transportation. So it's not like the power is limited to the actual transaction in which the goods or services are traded. The real disputes regarding this power have more been focused on the rest of the section. That is, what counts as trade and commerce with other countries or among the states? It's pretty clear that if an enterprise produced and manufactured its goods within one state and then sold them in that state from its store in that state, well, that wouldn't fall within the Commonwealth power, and so the Commonwealth couldn't regulate that activity. But the real world is seldom so neat. We're going to look at 2 series of cases which we'll call the airline cases and the meat cases. Now, airlines and aircraft are not actually mentioned in the Constitution, which is hardly surprising given that the Constitution commenced in 1901 and the Wright brothers didn't make the first powered flight until 1903. However, the nature of aircraft is that they travel long distances quickly, and so a lot of their activity goes from state to state or from Australia to places overseas. It follows that a lot of commercial aviation activity will add up to interstate or overseas trade. The Commonwealth passed its first legislation in this area in 1920 when it passed the Air Navigation Act. 14 years later, a fellow named Burgess piloted an aircraft at Mascot in Sydney, but he didn't have the pilot's licence required under the Air Navigation Act. He was charged with an offence under the Air Navigation Act, and the matter went to the High Court. Well, the High Court decided that since his activity remained entirely within New South Wales, it was not interstate or overseas trade or commerce, even though his flights might put him in proximity with interstate or overseas flights. The courts did, however, say that if it ever got to the point where the intrastate and interstate aspects of flight were so intermingled that it was impossible for the Commonwealth to regulate one without the other, then the Commonwealth might be able to regulate the whole lot. Aviation was back before the courts 10 years later in Australian National Airways against the Commonwealth. This is known as the Airlines case. In this case, the Commonwealth had established an Airlines Commission, which started operating an airline, which was then known as TAA, or Trans-Australian Airlines. If, like me, you're old enough to have once taken a flight on TAA, well, that'll be a nice little nostalgic moment for you. TAA had an effective monopoly on interstate commercial flights. And the law was challenged on the basis that the constitutional power under Section 51(1) only allowed the Commonwealth to make laws about the interstate and international trade. It didn't allow the Commonwealth to actually operate trading enterprises. Well, the High Court disagreed, finding that the trade and commerce power did allow the Commonwealth to do so. So can you see how those couple of little words in the Constitution keep getting fought about back and forth in the High Court, and we gradually find out what they mean and also what they mean at any particular point in time? You see, 20 years later, the High Court had to have another go. 20 years later, the High Court found that the Commonwealth was allowed to impose regulations even on intrastate flights, because they'd now reached the point where the regulations were necessary for the safety, regularity and efficiency of all air operations generally. However, even in that case, the High Court was careful to say that that didn't extend to a general right to regulate all aspects of aviation. Finally, in a case in Western Australia, the Commonwealth Government's airline, TAA, wanted to commence a route from Darwin to Perth. But to be financially viable, it would have to stop at Port Hedland in WA. This, of course, meant that the Port Hedland to Perth part of the route was within a state. So was the whole flight interstate trade because the Perth to Darwin route couldn't operate without the stopover? The High Court said no. Now, I've gone through these cases in quite a bit of detail, more than I will for others, so you can see what the High Court has to do when it looks at whether legislation is validly made under Section 51. There are other important trade and commerce cases. For instance, 3 cases looked at the question of Commonwealth regulation over factories or workshops or abattoirs if they are manufacturing or producing goods for both intrastate and interstate trade. Can the Commonwealth regulate? In essence, the rule is that the Commonwealth can regulate the entire enterprise, even if only quite a small proportion of the products will be traded across borders, as long as the manufacturing or production process is integrated, so that products for interstate and overseas trade can't realistically be separated from the rest. And that makes sense. Someone who's working on a chicken processing line might have no way of knowing whether any particular chicken was going to be eaten in Brisbane or Ballarat or Beijing. So the only way to regulate the cross-border products is to regulate the whole lot. Finally, Commonwealth control over export licences allows it to reach in and regulate a whole bunch of ancillary and related matters, just by making them conditions for obtaining an export licence. Since 2006, however, the Commonwealth's control over intrastate trade has expanded considerably because the Commonwealth can use its corporations power, which we'll discuss in a few minutes. They can use that power to make laws on just about any topic, as long as it binds financial and trading and financial corporations formed in Australia or overseas. The residual amount, trade and commerce within a single state, conducted by some entity which is not a corporation, that's a pretty small residue indeed. All right, let's move on from trade and commerce, but we're going to stick with money issues for a few more minutes and discuss the Commonwealth powers in relation to borrowing and banking. But can you see already that what the Constitution does is it decides what power the Commonwealth Parliament has? If the Constitution doesn't provide the power to the Commonwealth, and if the High Court doesn't agree that the Constitution provides that power to the Commonwealth, well, the Commonwealth Parliament can't do diddly squat. Let's look at banking. The Commonwealth Government has the power to make laws with regard to banking in Australia. Now, these days, this power mostly relates to the regulation of the financial system. However, in the dim dark past, this power was relied upon to create the Commonwealth Bank of Australia, which was once a public-owned bank, and it was used in an ill-fated attempt by a Labor government in 1947, which tried to nationalise all the banks in Australia. That is, it tried to have the Commonwealth Bank take them all over. Now, that attempt failed on other grounds, but there was no doubt that the banking power gave the Commonwealth the power that it needed to pass that legislation. Strictly speaking, the Commonwealth can't regulate state banks that only operate in their own state, but that exception is virtually theoretical in our modern banking system. In addition, the Commonwealth is empowered to raise money on the credit of the Commonwealth. In plain language, the Commonwealth can borrow money, for instance, by issuing bonds. The problem is, of course, that the states also have the power to do the same. It's not really in anyone's interest for the Commonwealth and the states to be competing with one another for debt, is it? So in 1927, the Commonwealth and the states made a financial agreement under which they would coordinate their borrowing. This agreement was last updated in 1994, and it's managed by a body called the Loans Council, which is a meeting of relevant ministers from the Commonwealth and state governments. Okay, I promise that we're going to come to the end of all this boring financial stuff. But the truth is the Commonwealth of Australia wasn't created for a bunch of noble nationalistic purposes. A great part of the motivating factor for writing the Constitution in the first place was these financial issues. So let's persevere for just a bit more. The next power I want to talk about is the Commonwealth's power to make laws regarding customs duties and excise duties. Customs duties are taxes which are paid by importers or more rarely exporters of goods. So to take an obvious example, when tobacco is imported into Australia, there is an excise of roughly 70 cents per cigarette. So that's roughly $21 on a 30 pack of cigarettes. Excise is a tax which is paid at some point in the production of some goods and services. So to take the same example, if cigarettes are manufactured in Australia and not imported, then the manufacturer has to pay an excise of, you guessed it, 70 cents per cigarette. So somebody who's importing pays 70 cents a stick and somebody who's manufacturing pays 70 cents a stick. But one of them is a customs duty and the other one is an excise duty. Now these duties were originally intended to give the Commonwealth the capacity to raise revenue. But customs duties have also historically been used by governments who followed a policy of protectionism to make Australian-made goods more competitive with imported goods by imposing customs duties on the imports, basically forcing up the price of the non-Australian product. Nowadays, Australia's policy, and the consensus policy internationally, is that excise should not be used in a protectionist way. There are still customs duties, but now they're only imposed in accordance with the rules established by the World Trade Organization, and those rules would need another 2-hour law course all on their own. Section 51(20) of the Constitution allows the Commonwealth to make laws with respect to foreign corporations and trading and financial corporations formed within the limits of the Commonwealth. Over time, this has become one of the broadest powers used by the Commonwealth. Let's start by asking what a corporation is. A corporation, in essence, is an organisation, so a company or an association, which is given legal personality. So the corporation becomes a legal person, with many of the rights and obligations of a natural person. So, for instance, corporations can own property. They can sue and be sued. But they don't have all the rights and obligations of a natural person. For instance, they can't be sent to jail and they can't vote. So the Commonwealth can make laws with respect to both foreign corporations and corporations formed within the limits of the Commonwealth. Now, this is one of those times when grammar becomes crucially important in the law. Notice the tense of that verb. The Commonwealth can make laws with respect to corporations formed within the limits of the Commonwealth. Formed, past tense. So what that means is that from a constitutional perspective, the states control the formation of corporations, but once those corporations are in existence, it's then the Commonwealth that regulates them. In 2001, this anomaly was overcome when the states referred their powers over the formation of corporations to the Commonwealth. The states are allowed to do that, and we'll talk about referral later. So once the states had handed those powers over to the Commonwealth passed the Corporations Act 2001, which is a comprehensive Australia-wide law regarding corporations. Now the next question is, what sort of activities of corporations can the Commonwealth regulate? Because when you think about it, there are two ways to see this power. One is to say, well, if the Commonwealth is regulating corporations, it should be able to regulate everything about those corporations. So for instance, if the corporation drove motor vehicles, maybe the Commonwealth should be able to control the registration and roadworthiness of those motor vehicles, even though the states already have perfectly good systems to do that. The other way to look at it is to say, well, the Commonwealth's power should be much more limited, because the original deal between the states was intended to refer minimal legislative power to the Commonwealth. We'll stick with that. Originally, the narrower view was taken. I mean, after all, we've already learned that the Constitution gave power over intrastate trade to the states. Now, there'd be no point in that provision if the Commonwealth could simply regulate the activities of the corporations conducting that intrastate trade, would there? You see the standoff? Well, in a case known as the Concrete Pipes case, the High Court found that there was nothing in section 51(20) which suggested that its operation should be limited by the trade and commerce power. As a result, the extent to which the Commonwealth could regulate corporations expanded out of sight and mind. The Commonwealth became heaps more powerful. The most recent significant case on the corporation's power was known as the Work Choices case. The Commonwealth Government passed legislation which was intended to implement a whole new industrial relations system across Australia. The new system, for the first time, would really crush the capacity of the states to regulate industrial relations and paying conditions for workers. The whole plan was a matter of huge contention and debate within politics and Australian society at the time. It was the sort of quite extreme legislation that would normally have been moderated by the Senate. But the government at that time had a majority in the Senate, so there was no institution there to save it from its own excesses. The new legislation relied almost entirely on the corporation's power. Essentially, the Commonwealth was saying, if you work for a corporation, then we can use the corporation's power to regulate that employment relationship. The states went to the High Court, arguing that this was pushing the corporation's power too far, because the Commonwealth's true intention was not to regulate corporations, but rather it was to regulate industrial relations. And there's another more limited industrial relations power in Section 51 of the Constitution already. The High Court, though, found that the legislation was within the corporation's power. So where does that leave us? The rule as it stands is that if a law creates a right for a corporation, imposes an obligation on a corporation, or regulates the conduct of those people through whom the corporation acts, then the law falls within the corporation's power. This is an incredibly broad interpretation. It's part of the trend over time whereby the Commonwealth has become more and more powerful at the expense of the states. Interestingly, the work choices legislation might have been constitutional, but it was deeply unpopular, and it was a key reason for the government losing the following election in 2007. After that election, the laws were immediately repealed, but the constitutional principle remains. Next, we're going to consider Section 51(29), which gives the Commonwealth power over external affairs. Just 2 words in the Constitution, but boy oh boy do those 2 words pack a punch. I mean, it makes sense, of course, for the Commonwealth to have power over external affairs. I mean, Australia has a seat at the United Nations, not Queensland or Victoria or South Australia. Australia makes treaties with other countries. Australia sends teams to the Olympics and issues passports and operates borders and goes to war and does all of the other things that happen when nations deal with one another. In fact, historically, one of the key reasons for federation was to obtain power over foreign affairs, which had previously been managed by the British Colonial Office. The great thing about the external affairs power is that while there's a range of case law, pretty much everything that you'll ever need to know about the external affairs power, for undergraduate purposes anyway, can be found in the Tasmanian Dams case. Now, this case happened after the Tasmanian government proposed to build a hydroelectric dam which would have flooded the Franklin River. Now, it would have completely destroyed a pristine wilderness area. In 1982, UNESCO, the United Nations Educational, Scientific and Cultural Organisation, approved an Australian nomination of the Franklin River area as a World Heritage Area. In 1983, the Australian Labor Party government under Prime Minister Bob Hawke, or in fact they were then the opposition under Bob Hawke, campaigned and won a federal election, largely on the promise to save the Franklin. They then passed legislation that would prevent the construction of the dam. The Tassie government objected and everyone headed off to the High Court. The Commonwealth claimed that its legislation was valid because that legislation implemented Australia's obligations under a UNESCO convention. The Commonwealth won, and the Franklin was saved. So much for the dam. What did the case mean for the law? Well, the High Court established 4 categories of legislation, which can each be said to be legislation pertaining to external affairs. First, legislation which directly relates to things outside Australia is external affairs legislation. Now, it seems pretty obvious. So, for instance, the Commonwealth Criminal Code contains an offence of bribing a foreign official. If an Australian who is overseas bribes a foreign official, they commit an offence under Australian law, even though they're not in Australia at the time. Second, legislation which affects Australia's relationships with other countries is external affairs legislation. This doesn't actually occur so much as an independent basis for legislation. I mean, lots of things might affect Australia's relationships with other countries, but they're usually under treaties, which we'll talk about in a moment. However, legislation forbidding Australians from travelling overseas to fight in civil wars is an example that I've come up with. That might be legislation affecting our relationship with other countries, because those other countries generally don't like people coming along to fight civil wars. Third, legislation which changes Australian law to deal with a matter of international concern is external affairs legislation. Again, though, this one's pretty rare. You see, sometimes international law is not based on treaties or agreements, but rather on what they call the customs of the nations of the world. They call this customary international law. Now, if the Commonwealth makes legislation to observe these international customs, well, that would be a matter of international concern. It's actually pretty hard to find an example, though, because most of the real areas of international concern are now governed in international law by treaties rather than by custom. Finally, and this is the one that matters, legislation which is passed in order to implement international agreements is external affairs legislation. And obviously this makes sense. If Australia goes off to the United Nations or to APEC or to any of the other international organisations that we belong to, and if Australia as a whole makes treaties or agreements with other countries, well, those treaties would be meaningless if the Australian government didn't have the power it needed in order to implement those agreements. So in the Tassie Dams case, the Commonwealth had obligations under the UNESCO agreement to protect World Heritage Areas, and it implemented legislation to do so, to protect the Franklin River, which was a World Heritage Area. At that level, it seems simple enough. But then there are some questions. First up, the truth is that most international agreements are not actually binding. Each country retains its own sovereignty and is able to exit treaties pretty much whenever it wishes. I mean, the United States under Donald Trump has given us a number of examples. In addition, lots of international agreements are never intended to be binding. They're aspirational or in-principle agreements. So if an agreement doesn't create a binding obligation as such, can it be the basis for Commonwealth law? I mean, the Commonwealth can hardly say that it's implementing the law because it has to. Well, in the Tasmanian Dams case, the High Court said that if Australia started to make treaties and agreements but then didn't deliver on them, even though they're not binding, then Australia's unreliability would have an effect on our nation's relationship with other countries. And so legislation which implements those non-binding obligations is still external affairs legislation. There are still some issues though. How do we tell whether legislation is really implementing our international obligations? I mean, what if the Commonwealth started to really push the envelope in terms of the relationship between the legislation and the obligations? For instance, what if the Commonwealth used that UNESCO power to try to make laws regarding the Franklin River that had absolutely nothing to do with its World Heritage value? Well, the bar is actually quite low. Any legislation which is reasonably capable of implementing an international obligation will be valid. This is important because it preserves the separation of powers. It means that the government, not the High Court, is deciding how Australia's international obligations will actually be implemented. Finally though, what if the Commonwealth government is being really sneaky and concluding agreements with other countries for the specific purpose of grabbing extra power and making legislation in areas which it normally wouldn't be able to? Well, in the Tassie Dams case, the High Court said that the international agreement had to be a bona fide international agreement, which sounds well and good, but it's really for the Commonwealth government to decide what agreements Australia should enter into and which agreements are in our national interest. If the Commonwealth government claims that an agreement is a bona fide agreement in our national interest, well, it would have to be a pretty blatant try-on for the High Court to intervene. Next, the Constitution gives the Commonwealth a number of powers relating to defence. First, section 51(6) gives the Commonwealth the power to legislate with respect to the naval and military defence of the Commonwealth and of the several states, and the control of the forces to execute and maintain the laws of the Commonwealth. Then section 51(32) gives the Commonwealth control of railways with respect to transport for naval and military purposes in the Commonwealth, although that's really a rather dated provision in the modern world. The defence power in section 51(6) though is then supplemented by a number of other important powers. First, Section 68 of the Constitution makes the Governor-General the Commander-in-Chief of our naval and military forces in the Commonwealth. And in the modern context, this of course also includes the Air Force. Now, naturally, this doesn't mean the Governor-General themselves is going to be sitting in the command post giving orders. These days, Command-in-Chief of the military is exercised for all practical purposes by the Chief of Defence Force, who answers to the Minister for Defence. Section 114 of the Constitution forbids any state from raising their own military force. And as a matter of history, Section 69 of the Constitution transferred the previous colonial military forces to the Commonwealth on federation. In return, however, the Commonwealth is obligated under Section 119 of the Constitution to protect each state against invasion and also against internal violence if the state requests support. Really, though, all these provisions centre around the fundamental defence power in Section 51(6). And of course, it makes sense for the nation as a whole to have a single defence force, especially as the Commonwealth manages external affairs. I mean, defence is really just external affairs with weapons. The Commonwealth has made a range of legislation under the defence power. Probably the two most important are the Defence Act 1903, which establishes the Defence Force and sets out its frameworks, and the Defence Force Discipline Act 1982, which provides our system of military law, which underpins the disciplined nature of our military service. There are three key aspects of the defence power that I want to mention: the defence power during a time of war, the defence power during a time of peace, and the defence power in relation to threats which do not fall neatly within our customary concepts of warfare. During a time of war, the defence power can be so broad it's almost limitless. The Commonwealth can control employment, access to goods, movement of people, access to information, you name it, they can control it. Naturally, for powers so broad to be used, the country would need to be engaged in total warfare of the type experienced by the free world during the Second World War. It's unlikely that the Australian people would accept the overzealous use of the defence power by the Commonwealth using war as a pretext. I mean, as a result, while Australia's been at war in Afghanistan and Iraq for 15 years, this hasn't resulted in any effort by the Commonwealth to use this defence power as some sort of general legislative mandate here at home. Similarly, during the First World War, while it was open to the Commonwealth to introduce conscription, the government went to the people twice in referenda to ask whether conscription should be introduced, and the government abided by the public refusal in each case. In a time of peace, such as the period between the end of our involvement in the Vietnam War in 1972 and the commencement of our armed support for East Timor in 1999, the defence power is construed much more narrowly. It generally provides the power that's required by the Commonwealth to recruit, train and equip our military forces to ensure that they remain in an appropriate state of readiness to conduct operations. Now, this can still be quite a broad range of powers, but it's much narrower than during time of war. Those two situations, war and peace, are fairly easy to understand. However, the real world is rarely quite so neat. Sometimes threats to Australia's security might occur in ways which fall short of outright warfare. In essence, any threat to Australia might be met by legislation under the defence powers. So, for instance, laws intended to address the threat of terrorism have been considered to be valid uses of the defence power. In a similar way, laws which seek to protect Australia's borders against people smugglers and foreign fishing incursions have been considered as valid laws under the defence power, and also as valid occasions for Australian Defence Force personnel to undertake operations. Mention of protecting Australia's borders brings us neatly to the next area of Commonwealth power, immigration and emigration. There are a couple of provisions in Section 51 which are relevant here. The most obvious, of course, is Section 51(27), which quite simply gives the Commonwealth power over immigration and emigration. Simple. However, this is supported by three other provisions. The first, Section 51(9), relates to quarantine, which was much more important than ever back in the times before widespread vaccination allowed us to manage or eradicate infectious diseases. Next, Section 51(29) gives the Commonwealth power over naturalisation and aliens. No, not the sort of aliens who arrive in spaceships, but rather citizens of other countries who arrive in Australia. So the Commonwealth can make laws with respect to foreign nationals and with respect to those arrivals who then become Australians. Finally, and from something of a historical perspective, Section 51(28) gives the Commonwealth powers with respect to the influx of criminals. This was a result of a 19th century situation where the government of France sent many of its worst criminals to New Caledonia, a French colony just 1,000 or so kilometres off the Queensland coast. Many of those criminals, known as the recidivists, jumped on the first boat they could and made their way to Australia. This problem was very much on the minds of those delegates at the constitutional conventions. It's obviously not really a problem now. The Commonwealth has primarily implemented these powers through the Migration Act 1958, which regulates entry into Australia, and the Australian Citizenship Act 2007, which regulates the acquisition of citizenship. The constitutional powers in this area are very broad. Basically, the Commonwealth can set whatever rules it likes in relation to immigration and also in relation to citizenship. Historically, this was used for many decades to exclude non-white people under the Immigration Restriction Act 1901. That act implemented what was known as the White Australia policy. This power is also used along with the External Affairs power in relation to Australia's obligations towards refugees. It's one of the constitutional powers which enables the policy of mandatory detention of refugee claimants. The whole area of migration causes a very considerable portion of the High Court's workload as refugee claimants appeal against decisions against them. However, those cases are usually matters of administrative law. The constitutional validity of this power is rarely tested. When it has been tested, the system of mandatory detention has been found to be constitutional. Whether it's reasonable or the right thing to do is a question for the public and the legislature, not the courts. Next, we're going to think about marriage and divorce. Section 51(21) of the Constitution gives the Commonwealth the power to make laws with respect to marriage, and then the following section gives the Commonwealth the power to make laws with respect to divorce and matrimonial causes, parental rights, the custody and guardianship of infants. So between them, those two provisions give the Commonwealth virtually full authority over marriage. In the 1890s, when the Constitution was written, that meant the Commonwealth had virtually full authority over the beginning and end of adult relationships because marriage was, well, if not universal, certainly the overwhelmingly dominant way of managing the affairs of people. Strangely, though, the Commonwealth was not quick to use this power. For the first 6 decades of federation, marriage continued to be managed by state law. Divorce was a fault-based system, often bound up in tort law, where adulterers were sued for the damage they had allegedly caused to relationships. It wasn't until 1961 that the Commonwealth passed the Marriage Act 1961, instituting an Australia-wide system. The difficulty was, though, that from the 1960s onwards, the sexual revolution began to challenge the way that Australians formed families. And by implication, it challenged the ways in which those families ended. De facto relationships and the welfare of children not born within marital relationships was potentially outside the scope of the Commonwealth's power. In 1975, the Commonwealth introduced the Family Law Act 1975, which made a number of changes to the system of family law in Australia. One notable change was the introduction of no-fault divorce. Parties who wanted to obtain a divorce would no longer need to sue the other party to show grounds for divorce. Nobody gets the blame. At the same time, all of the states other than Western Australia referred all of their parenting powers to the Commonwealth. So since then, we've had the Family Court of Australia and more recently the Federal Circuit Court of Australia, which handled property matters for married couples separating and all parenting matters. Finally, in 2008, the Commonwealth took over de facto property matters too. In Western Australia, however, there's a separate court, the Family Court of Western Australia, which manages family law issues in WA. The word marriage in the Constitution is not locked into the meaning of marriage as it stood in 1900. At that time, civil marriage was very unusual, as was marriage between people of different races or people of different religious denominations. And certainly same-sex marriage was impossible. However, as our understanding of marriage has evolved, so have the Commonwealth's powers in relation to those marriages. Most recently, of course, the definition of marriage has been changed to allow for same-sex marriages. Even though that decision was preceded by what they referred to as a postal survey or a postal plebiscite, there was actually no constitutional reason for that to happen. The Commonwealth has always had the powers that it needed to make that change. Let's move on now and talk about the social security system. We might not realise it because we've mostly grown up with this situation, but Australia has a far more developed social security system than many other comparable nations do. And social security has really been part of our governmental system since the very start. Two provisions of the Constitution relate to social security. Section 51(22) gives the Commonwealth the authority to legislate with respect to invalid and old age pensions. Section 51(22)(a), which was implemented after a referendum in 1946, then expanded this to the provision of maternity allowances, widows' pensions, child endowment, unemployment, pharmaceutical, sickness and hospital benefits, medical and dental services, benefits to students, and family allowances. Some of these powers are pretty clearly limited to the provision of financial support, such as pensions, allowances, and endowments. However, benefits and services are a bit broader. So they might include things like the direct provision of services, but the services have to be sufficiently directed to the benefit of the target group. So, for instance, the power to legislate for benefits to students is not a general power to pass laws for the benefit of students. I mean, that would ultimately give the Commonwealth complete power over education. Next, we're going to return to financial issues briefly, albeit financial issues which operate at something of a lower level than the corporation's power or the trade and commerce power. We're going to look at bankruptcy and also copyright issues. Bankruptcy is a legal situation where a person who is unable to service their debts either voluntarily submits or is forced by their creditors to submit to having their financial affairs supervised. The idea is to try to minimise the loss to the creditors while preventing the bankrupt person from becoming completely destitute. All of this happens under a Commonwealth piece of legislation, the Bankruptcy Act 1966, which is authorised under Section 51(27) of the Constitution, which simply gives the Commonwealth legislative power to make laws with respect to bankruptcy and insolvency. So we have one bankruptcy system right around Australia. Next, Section 51(18) of the Constitution allows the Commonwealth to legislate with respect to copyrights, patents of inventions and designs, and trademarks. In essence, this gives the Commonwealth control over intellectual property law in Australia in relation to everything from the protection of designs of integrated circuits in computer gaming console systems to the question of whether one iconic Australian song, Men at Work's Down Under, sampled another iconic Australian song, Kookaburra Sits in the Old Gum Tree. In a sense, though, this power is almost redundant, since copyright law internationally is bound by what they call the Berne Convention for the Protection of Literary and Artistic Works. This is an international convention which has been in place since the 1880s and which would therefore have been known to the constitutional drafters. So the Commonwealth could regulate copyright just using the external affairs power. Patents are similar, but perhaps a little more commercial. They're granted for a device, substance, method, or process which has been invented by the initial holder of the patent and which then can't be used by others unless they have the agreement of the patent holder and usually pay a fee or a royalty. This is to encourage inventors and innovators to devise new devices and new substances and methods and processes, knowing that they'll be able to reap the benefit of that innovation, rather than just having anyone else steal it and use it. In Australia, patents are regulated by the Patents Act 1990. Finally, trademarks are devices used by a commercial enterprise to distinguish their own product or service from their competitors. So this is everything that comes to mind when you think about branding. Logos, slogans, mascot characters, things like that. These can all be protected by trademarks so that competitors can't just come along and pretend to be you. Okay, we're getting seriously close to the end of the Section 51 powers that I'm going to talk about in this video. 2 more to go. Next, I want to talk briefly about what I'm calling matters of consistency. These are really basic things that truly do need to be consistent across the entire Commonwealth. Section 51(5) gives the Commonwealth control over postal, telegraphic, telephone and the like services, which nowadays includes the internet. I mean, it'd hardly make sense for Queensland and New South Wales to have separate phone networks. Section 51(7) gives the Commonwealth control over lighthouses, lightships, beacons and buoys for sea navigation. Again, it's helpful for the safety of shipping for these things to be consistent, and shipping is still crucial to our island nation. Section 51.12 gives the Commonwealth control over currency, coinage and legal tender, and with it Section 51.16 gives the Commonwealth control over bills of exchange and promissory notes. That goes along with Section 115 of the Constitution, which forbids the states from coining money of their own. I mean, could you imagine our nation operating as a nation if the currency in Western Australia was not the same as the currency in Victoria? For the same obvious reasons, Section 51.15 gives the Commonwealth power over weights and measures. So a kilogram is a kilogram everywhere around the country. Although this is another area where there are now a bunch of international treaties, so the external affairs power would probably have the same effect. Last but not least, I want to talk about referred powers. The drafters of the Constitution were smart enough to realise that it was impossible for them, sitting there in the 1890s, to have any real conception of what the future held for the nation they were creating. Now, 130 or so years later, our world is unimaginably different to the world of the constitutional conventions. And so the drafters included a provision, Section 51.37, whereby the states can refer powers to the Commonwealth. So if you remember the start of this section of the video, I said that any power not specifically set out in the Constitution remained with the states. If the states want to give up any of that power, well, they're entitled to do so. And this has happened from time to time, where the states have collectively decided that it was inefficient or ineffective for each state to be separately administering some area of policy. The example I'm going to use here is consumer credit. So everything from credit cards to hire purchase agreements. The Commonwealth has no specific power under Section 51 to make rules about consumer credit at all. I mean, maybe the Commonwealth might twist some aspects of the trade and commerce power or some aspects of the corporation's power so that it had control over some aspects of consumer credit, but that'd all be a bit awkward and not necessarily all that effective. Well, in 2008, the Council of Australian Governments, or COAG, which is basically a meeting of the Prime Minister and the Premiers or Chief Ministers of all the states and territories, decided to refer their powers over consumer credit to the Commonwealth, so that there would be a uniform national scheme administered by the Commonwealth right around the nation. Okay, so there we have it. Now that's certainly not every power granted to the Commonwealth by Section 51, but those are the ones you're most likely to come up against in an undergraduate law unit. And generally speaking, Section 51 issues will take up about half your unit. That also brings us to the end of our discussion of the first of the three estates of power, the legislature. We now know about the shape of the Parliament, we know how it makes laws, we know how it obtains its power to make laws, and we've talked about some of the areas in which the Commonwealth can make laws. The second estate of power and the second chapter of the Constitution relates to the executive government. So this is the branch of our government which carries the laws into effect. It includes a vast range of people. The Prime Minister, Ministers of State, CSIRO, scientists, aviation regulators, customs officials, policy developers, a whole lot of lawyers, artillerymen, submariners, meteorologists, Centrelink workers, you name it. Out of the three estates of power, it employs the most people by a long way, and it spends the most money. And really, most of its powers come down to just a few sections of the Constitution. First up, it's important to understand that the executive branch of the Commonwealth is split into a range of areas called portfolios. These cover a really broad area of policy. So, for instance, there's currently a Commonwealth portfolio called Education and Training. Each portfolio is led by a senior minister, and they're often assisted by junior ministers and other parliamentarians known as parliamentary secretaries. The ministers are usually just referred to as ministers, other than the Prime Minister, the Treasurer, and the Attorney General. The portfolio itself consists of a department, and occasionally more than one department. For instance, the Defence portfolio includes both the Department of Defence and the Department of Veterans Affairs. In addition to the department, there's often a number of separate agencies. So within the Education and Training portfolio, we have the Department of Education and Training, and then agencies including the Australian Research Council and the Tertiary Education Quality and Standards Authority. Section 64 of the Constitution allows the Governor-General to establish these portfolios and to appoint ministers to lead them. Again though, while it looks like the Governor-General holds the power here, an extremely strong convention exists whereby the Governor-General does as the Prime Minister requests. So it's really the Prime Minister who decides what departments will exist and which ministers will be appointed to lead them. Section 64 also makes it clear that ministers must be members of Parliament. They can be either members of the House of Representatives or senators, but they must hold a seat in Parliament. The second important thing which the Constitution does is that it establishes the financial relationship between the Parliament and the Executive. Remember at the start I said that instead of a separation of powers, we have a system of responsible government? Well, one of the ways in which this system of responsibility operates is that in general, the executive government can't get its hands on public money unless the Parliament agrees by passing what are called appropriations bills. These are basically bills by which the Parliament grants to the executive government large amounts of money for particular purposes. And then the executive government, if they want more money, have to report back to the Parliament on its spending. This all happens through what is known as the budget process and the estimates process. And it's all underpinned by a number of sections of the Constitution that provide for these appropriations bills. Finally, while the senior-most members of the executive, the ministers, are members of Parliament, there are tens of thousands of public servants who are not. Instead, they are appointed under a constitutional head of power in section 67, which the Commonwealth Parliament has then used as a basis to pass the Public Service Act. These public servants are supposed to be politically impartial. They're supposed to give frank and fearless advice to the ministry. The extent to which this happens is highly debatable, but it's really a matter for discussion in your admin law course rather than in this one. The third of our estates of power, and chapter 3 in the Constitution, is the judiciary. The Constitution creates a new institution called the High Court of Australia to be the judicial institution in Australia. Now, I'm not going to bore you to death by describing what we mean by a court. However, remember earlier in this video when we were discussing the separation of powers? Well, the separation of powers is really crucial when it comes to the courts, because as you'll have already picked up in this video and the previous ones, it's not at all uncommon for the Commonwealth Government itself to be a litigant in court matters. And of course, it's always the Commonwealth Government prosecuting in any Commonwealth criminal matter. So if the courts were not independent from the government, well, that really would be tyranny. I mean, you don't need to look too far to find developing countries around the world where there is no independent judiciary and where the judges simply make the decisions that the government demands because they're really left with no other option. How does the Constitution accomplish this separation? Well, there are three factors. First, once judges are appointed to the High Court, they hold office until they turn 70 years of age. The only exception is if both Houses of Parliament separately find that a judge has either misbehaved or become incapable of being a judge. So while it's the government through the Attorney-General that nominates High Court judges, once they've been appointed, they're beyond the reach of that government or any other government. They can make whatever decisions seem right to them according to law, without any fear whatsoever of being dismissed from office. That simple fact is one of the most important factors ensuring that Australia's system of rule of law remains intact. Second, there's a rule that judicial power in the Commonwealth can only be given to a court. So the High Court and other Chapter 3 courts with judges appointed until they turn 70, they're the only types of court that can exercise Commonwealth judicial power. This monopoly power is crucial because it means that a tyrannical government could not undermine the High Court by setting up, say, a rival court with the same powers, but under political control. Thirdly and finally, there's a rule that the High Court may only be given judicial power. I mean, it has a few very basic forms of executive power. For instance, it can hire staff. Otherwise, though, the High Court and the other Commonwealth courts can't use either legislative or executive power. This stops the judges from becoming too powerful. So they get a monopoly over judicial power, but that's all they get. All of this begs the question, of course, of just what we mean by judicial power in the Commonwealth. Strangely enough, this is one of those concepts that seems so obvious that it actually becomes difficult to adequately describe. I mean, what sort of power is judicial power, and how does it differ from other sorts of power? Well, Australian constitutional jurisprudence points to a number of factors which, together, describe judicial power. First and foremost, I said at the outset of this video when talking about the three estates of power that judicial power is adjudicative in nature. In other words, you only use judicial power when there's a dispute between two parties as to their respective rights and obligations, and that dispute needs to be settled. For this reason, in Australia, the High Court and the other federal courts can only use their powers in relation to a matter which is brought before them. So there has to be two sides in a genuine dispute which requires resolution by the courts. Now you can see straight away that this is quite different to legislative or executive power. I mean, the Parliament can make laws on its own initiative as soon as it identifies a need for legislation. The executive can create government programs or modify the ways in which it implements laws as soon as they realise there are better ways of doing things. The High Court can't do anything like that. The court has to wait until a matter is brought before the court and then make a decision on that particular matter. Those of you who've read a few judgments will know that judges are often sometimes slightly cheeky, and they seize opportunities to make pronouncements in obiter dictum, which are not completely related to the case at hand. But even there, the judge's statements in obiter have to hang off some aspect of the actual trial. Strangely enough, there's nothing actually inevitable about this restriction. In some other countries, such as Canada, for instance, it's possible for the government to submit a question of law to the courts to obtain an authoritative interpretation or opinion, even without there being an actual dispute. In Australia, though, there needs to be a dispute, and the facts of that dispute then become the facts upon which the constitutional interpretation is based. The second important factor regarding judicial power is that a judicial decision is coercive. Now that sounds pretty horrible, really. We're used to coercion being a kind of negative word, used when people are being forced to do things they don't want to do. However, whether we like it or not, courts are coercive. If someone makes a civil claim against you, you don't have any choice about the claim proceeding. You don't have to show up, but if you don't, the court will find against you. If you're arrested, you don't have any choice about whether to show up. If a court makes a judgment against you and you refuse or fail to meet that judgment, then the court can issue warrants to have the judgment enforced. Now, courts in Australia use their powers very fairly and carefully by and large, but there's no getting away from the fact that a court is coercive. The other side of that coercive power is that in most cases, one of the parties which comes before the court is going to end up facing a decision which is made against its will. In other words, one party's going to lose. And the losing party must accept that they are bound by that decision, even though it's against their will. I mean, obviously they can appeal, but that doesn't change the coercive nature of the power. It just moves it up one step in the hierarchy of the courts. This is quite different to arbitration or mediation, where the parties attend voluntarily and the arbitrator or mediator only has the authority that the parties have granted them. The third factor regarding judicial power is that it's both binding and authoritative. What this means is that once a court has decided the rights and liabilities of two parties, then those are, by definition, the rights and liabilities of those parties. Now, you can appeal, of course, but again, an appeal is just from one court exercising judicial power to another court exercising judicial power. You can't appeal to any other type of power if you don't like the outcome in court. In the same way, you can't litigate the same matter all over again. There's a concept called an estoppel by record, which says that once a court has finally determined a dispute between two parties, that's the end of it. So that's the concept of the judicial power of the Commonwealth. It's adjudicative, used to resolve disputes. It's coercive, so you don't get a choice whether to participate or not. And it's binding. So once the court has settled a dispute, that's the end of the matter. Now, the Constitution only establishes one actual court, and that's the High Court of Australia, established in Section 71 of the Constitution. However, that same section also gives the Commonwealth the power to create other courts and the power to invest other courts with Commonwealth jurisdiction. Let's consider each of those separately, starting with the High Court. Now, in your introduction to law course, you most likely learned that the High Court consists of 7 judges, including the Chief Justice of Australia. And the High Court really has 3 roles. First and foremost, the High Court has the role of interpreting the Constitution and adjudicating any disputes directly relating to the Constitution itself. I mean, most of the cases that have been flashing across the bottom of your screen in this lecture fall under that category. Second, the High Court is our ultimate court of appeal. So if there's a matter which has been appealed up through a state court system to the Court of Appeal in that state, and there are still grounds for appeal, then the appellant party can seek special leave from the High Court to appeal to the High Court. But then, once the High Court has made its decision, that's the end of the line, the ultimate appeal. Finally, the High Court has a range of other areas of original jurisdiction. These include matters under treaties, matters in which the Commonwealth is a party, matters arising between states or between parties in different states, and matters where the decisions of a Commonwealth official are being challenged. In addition, the High Court has original jurisdiction in relation to matters under Commonwealth legislation, and particularly in relation to Commonwealth criminal offences. Now, if you think about it, there's no sensible way that 7 judges would ever be able to manage that workload, particularly not when you consider the complexity and importance of the appeal cases and constitutional cases which the High Court has to manage. And so we turn first to the Commonwealth's power to invest other courts with Commonwealth jurisdiction. You see, what the Commonwealth very sensibly did right back in 1903 was invest all of the state Supreme Courts with jurisdiction over most Commonwealth matters. So rather than duplicating the state court systems, the Commonwealth just gave those state courts the power to hear Commonwealth matters. In 1930, the Commonwealth first used its power to create additional courts in order to create a Federal Court of Bankruptcy. And then in 1956, the Commonwealth Industrial Court was created. Yet it remained the case that the vast bulk of Commonwealth matters were dealt with by state courts. The next really big change came with the Family Law Act 1975 and the Federal Court Act 1976, which established 2 equal superior courts with federal jurisdiction. So between them, those 2 courts started to really do a lot of the heavy lifting in terms of Commonwealth law. And yet the state courts still had jurisdiction to hear many Commonwealth matters, and they continued to do so. So at this point, we've got the High Court as the big kahuna, and then we have the state Supreme Courts, the Family Court of Australia and the Federal Court of Australia, all sitting below the High Court and all exercising different aspects of Commonwealth jurisdiction. The next chapter in the development of Commonwealth jurisdiction was a very strange little chapter indeed. In the late 1980s, there was a cooperative scheme developed which was intended basically to allow for corporations matters to be heard in any court, whether state or Commonwealth. This was important because if you remember at the time, the states had power over the incorporation of corporations, but once they were up and running, the Commonwealth had power to regulate them. Very messy, particularly if you had a dispute which related to both the incorporation of a company and its activities once it was incorporated. It made a lot of sense for the states and the Commonwealth to all get together and give one another's courts jurisdiction, so that all of those jurisdictional issues wouldn't get in the way of resolving disputes. The only problem is the whole scheme was soon challenged, and the High Court found that while it was perfectly okay for the Commonwealth to invest state courts with Commonwealth jurisdiction, it was not okay for the states to invest a Commonwealth court with state jurisdiction. Why is that? Well, if we wind this video back just a few minutes, you come to the part where I said that Commonwealth courts can only exercise judicial power of the Commonwealth. There's nothing in the Constitution about the Commonwealth courts enforcing state laws. So they just can't do it. The cross-vesting scheme, as they call it, still exists between all the states, but the Commonwealth courts still can't exercise state jurisdiction. The final step in the development of our federal court system was the development of the Federal Magistrates Service, which was soon renamed the Federal Magistrates Court and then finally renamed the Federal Circuit Court of Australia. This court acts much like the state magistrates courts as a lower level clearinghouse. It's extremely busy and handles a great many matters, particularly family law and migration. Now those are the courts, but there's also a range of bodies known as administrative tribunals, which act a lot like courts, but which are not actually courts, and so they don't exercise judicial power. This distinction really confuses a lot of students, so you may need to go over it a couple of times. And you may not fully understand it until you also study administrative law, which will fill in many of the gaps. But I'll try to explain. The executive government, by which I mean the public service, makes a whole bunch of decisions which affect the daily lives of people and corporations. If you're applying for a passport, a public servant decides whether to issue it. If a company is applying for an export permit, or an Indigenous Land Council is applying for recognition of native title, or an inventor is applying for a patent, or a veteran is applying for a service pension, then those decisions will be made by public servants. Inevitably, those public servants will sometimes make decisions which the applicant doesn't like. Now, once upon a time, the only real way to seek a review of those decisions was to take action in court, to seek remedies under various very old-fashioned writs, such as the writ of mandamus, which compelled a public servant to do something, or the writ of prohibition, which prevented them from doing something. Now, this process had a number of real disadvantages. First, it was legally quite complex. Second, the courts could usually only consider the legality of the decision and not its actual wisdom. So the courts could review the law as it related to a decision, but the courts couldn't review the merits of that decision. If the public servant made an awful decision, but they made that awful decision in full compliance with the laws binding them, well, then the courts couldn't interfere. Third, going to court was obviously terribly expensive, which meant that it was beyond the means of most people to seek redress in the courts. In 1975, the Commonwealth Government decided to do something about this situation, and it created the Administrative Appeals Tribunal, which is still with us today. Now, the Administrative Appeals Tribunal provides a place where people can appeal against public service decisions when they feel like the public servant has got it wrong. So one way to see the AAT is that it's a group of public servants who've been given the task of reviewing the decisions of other public servants who made the original decisions. Now, because the tribunal members are from the executive, not the judiciary, they're not limited to just considering the legality of the decision. They can also consider the merits. And if they disagree with the decision, well, then they can send it back for reconsideration, or sometimes they can just change the decision. So why isn't the tribunal a court then? Well, there are two reasons. First, the tribunal members are not appointed until age 70. They're expected to make independent decisions, but they don't have the security of tenure that we provide to judges. Second, though, and more importantly, if you think the tribunal has made its decision in a way that's not consistent with the law, then you can challenge the tribunal's decision in a court. This means the tribunal's decision is not final or determinative. It can be challenged in court. I think all of this makes more sense if we look at it visually. Have a look at this screen. On the top half of the screen, you can see an area with a red background. We're going to call that the judicial zone. Decisions in this zone are made using judicial power by a judge who has tenure until age 70, and decisions in this zone are binding and authoritative. On the bottom half of the screen, you can see an area with blue background. We're going to call that the executive zone or the administrative zone. Decisions in this zone are made by public servants. Now, under the former system, when our public servant down here in the executive zone made a decision, it could be challenged by taking it up to a court here in the judicial zone. But that was expensive, and the court could only review whether the decision was lawful. They couldn't consider whether the decision was actually any good. After 1975, the decision looked more like this. If the public servant made a decision which you didn't like, then you could go to the AAT and ask another public servant to review that decision. This was quicker and cheaper, and the AAT can consider both how the decision was made and whether the decision was any good. If after that you're still not happy, then you can take the matter up here into the judicial zone and seek a review of the decision in the courts. Okay, I promise we're nearly finished this judicial stuff. I've got only one more point to make. Sometimes the Commonwealth likes things to be resolved using alternative dispute mechanisms such as conciliation and arbitration. These are processes where instead of just imposing a judgment like a court does, a conciliator or arbitrator will assist the parties to arrive at an outcome on their own. Traditionally in the Commonwealth, this has mostly taken place in the context of industrial relations. The thing is, of course, that while judges might make excellent conciliators or arbitrators, we can't give those functions to the court. Why? Because decisions of a conciliator or an arbitrator are not binding or authoritative. And participation in these processes is not usually coercive. You get to decide whether to be involved or not. So those decisions are not made with judicial power. And we know from earlier that due to the separation of powers, courts can only be given judicial power. As a result, the Commonwealth has created a number of agencies such as the Fair Work Commission, which exists to help parties to resolve disputes between themselves. However, ultimately the Fair Work Commissioners are public servants using executive powers. They're not judges. So after all this, we can see our grand Commonwealth judicial scheme. At the top we have the High Court, which is our constitutional court and our court of final appeal. Next we have the Federal Court of Australia and the Family Court of Australia, which are Commonwealth Superior Courts of Record. And beside them we often get state Supreme Courts hearing Commonwealth matters. Beneath them, we get the Federal Circuit Court of Australia and the state magistrates' courts, who sometimes exercise Commonwealth powers. Then underneath these, we have a number of bodies which have similarities to courts, but which are not actually courts. They don't exercise judicial power and instead live down here in the executive or administrative zone. These are the administrative tribunals, where specialised public servants review the decisions of other public servants, and bodies which exist for conciliation and arbitration exist, where people are encouraged to resolve disputes between themselves. Phew! Okay, there's no getting around the fact that this stuff was a bit complicated, and obviously I'm trying to jam it into a few minutes as well. Have a listen a few times. I promise it'll make sense eventually, and it should really make sense after you've done administrative law. Alright, we're getting there, I promise. The video really only has 3 key sections to go. Next, I want to turn to the relationship between the Commonwealth and the states. Now, we've already talked right back at the start of this video about how that relationship was initially conceived. I mean, basically the idea was that the states were getting together to give up minimal amounts of power in order to form a national government which would take over those relatively few areas of law and public administration which were better managed on an Australia-wide basis. Now, the states tried to safeguard their position by the use of 3 different measures. The first one we've discussed already, and that was the concept of enumerated powers. That is, the Commonwealth could legislate in certain areas defined by the Constitution, while the states retained everything else. The second was a concept called implied intergovernmental immunities, which basically meant that the Commonwealth couldn't make laws affecting the state governments and vice versa. The third was that the states continued to have powers over taxation, except for customs duties and excise duties. So the idea was that the Commonwealth would be limited in the areas in which it could make laws at all, it wouldn't be allowed to make laws binding the state governments, and it wouldn't have access to too much money. Well, if you look at Australia now, how well has this intention stacked up? Do we still have an Australia with a very strong states and a limited Commonwealth, which is really only active in certain narrowly defined areas? No. These days, the Commonwealth is an absolute behemoth of a government, and it pokes its nose into 1,000 areas of law and public administration where the Constitution gives it no powers at all. How on earth has this happened? Well, we've already talked about how the High Court's interpretation of Section 51 of the Constitution really expanded Commonwealth legislative power. I mean, nowadays, any law affecting the legal rights or legal burdens of a corporation will be a valid Commonwealth law. And any law which can be said to meet an international legal obligation will be a valid Commonwealth law. We've talked about how those 2 issues alone led to a massive expansion of the power of the Commonwealth. However, this expansion of Commonwealth legislative power was supported by Section 109 of the Constitution, which says that when a state law is inconsistent with a law of the Commonwealth, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. In practical terms, this means that when the Commonwealth legislates in a particular area, it not only imposes new Commonwealth law, but it also invalidates any state law which is inconsistent with the Commonwealth law. So any new Commonwealth law also potentially reduces the areas in which the states can make laws. These inconsistencies can happen in a number of ways. There's what we call direct inconsistency, which happens when there's a direct conflict in the text of the Commonwealth and the state laws, so that you can't logically obey the 2 of them at the same time. Or where rights created by one law would be destroyed by the other law. In either of those cases, the state law would be invalid and the Commonwealth law would prevail. So those are both direct inconsistencies. Next, there's what we call indirect inconsistency. This happens when the Commonwealth introduces a law which is meant to, as they say, cover the field in a particular area of law. So if the Commonwealth is establishing a comprehensive scheme of law, well then it seems pretty clear that any additional laws passed by the states would just disturb that scheme. And so any laws by the states in such an area would be invalid, even if it was logically possible to obey both. So the concept of enumerated powers really failed to protect the states anywhere near as much as they expected. Next, let's think about how well the doctrine of implied intergovernmental immunities fared. As I mentioned a moment ago, this was the concept that the Constitution contemplated, that there would be a Commonwealth government and there would be state governments, and these would be separate but equal. So the Commonwealth shouldn't legislate in a way which would fetter the legislative power of the states. Initially, the Constitution did in fact work this way, primarily because Sir Samuel Griffith, who was the first Chief Justice of the High Court, had been one of the key drafters of the Constitution. So he knew exactly what the founders of the Constitution had intended because he was one. However, the concept of implied intergovernmental immunity started to break down very quickly. In 1920, in the Engineers case, the High Court held that implied intergovernmental immunities, in fact, didn't exist at all. The result of this is that the Commonwealth can make laws which bind the state governments. The only restriction is that those laws can't discriminate against the states. So they can't write laws specifically in order to affect the states differently to, say, corporations or individuals. They can't specifically bind state governments. This means the Commonwealth couldn't, for instance, change the rate of GST so that state governments had to pay 12% while everyone else paid 10%. In the same way, any Commonwealth legislation which has the effect of threatening the state's capacity to actually function as a government will be invalid. The Constitution is a federal constitution. It requires the continuing existence of the states, so anything which threatens the existence of the states will be invalid. An example of this occurred in 1985 when some long-running and serious strikes occurred as a result of conflict between the Electrical Trades Union and the Queensland Government's electricity authorities. The dispute was suitable for resolution under the state's arbitration processes, but the federal Labor government made new laws requiring a Commonwealth arbitrator to step in and resolve the dispute. You can see that this had the effect of completely undermining the government institutions in Queensland. The High Court declared the Commonwealth law in that case to be invalid. Basically, though, outside those two fairly narrow exceptions, the doctrine of implied immunities has really ceased to exist. The Commonwealth can make laws which bind the states. So far, then, we can see Commonwealth power monstering along. The areas in which it can make laws have expanded, and it's no longer constrained by the doctrine of implied immunities. But it gets worse. You see, under the original concept of the Federation, the Commonwealth was only supposed to have quite limited taxation powers, really just enough to fund its own operations, based primarily on tariffs and excise. And so it was until the Second World War. During the Second World War, as you can imagine, the Commonwealth needed money, a lot of money. And so the Commonwealth decided to start imposing an income tax. Now, income taxes weren't new, of course. The states all had various income taxes. So those were levied by the states and the proceeds were collected by the states. The Commonwealth proposed to collect income taxes from right around Australia. And they proposed to charge a higher rate than the states had been charging. After all, there was a war on. The Commonwealth government said to the states, "This is a temporary war measure. If you give up your income taxes, then we will reimburse you the full amount of income tax that you would have collected, and we will keep the extra. But if you don't give up your income taxes, then your citizens will have to pay double because we won't reimburse you." So they'll end up paying state income tax and Commonwealth income tax. The states, strangely enough, didn't like being blackmailed. They headed straight to the High Court, but the High Court decided in favour of the Commonwealth. The Commonwealth, they said, did have the right to collect the income taxes and did have the right to provide payments to the states on conditions such as the condition that the state remove its own income tax. The second part of the decision, that the Commonwealth could impose conditions on its grants, came straight from section 96 of the Constitution, which allowed the Commonwealth to grant money to the states on such terms and conditions as the Parliament thinks fit. Now, this was supposed to be a way for the Parliament to help equalise the financial situations of the states, so you didn't have super wealthy states and destitute states. It was meant for subtle adjustments. But after that first uniform tax case, the Commonwealth was suddenly given a sledgehammer. You see, somehow or another, the Commonwealth changed its mind about returning those income powers to the states at the end of the war, and so we ended up with a situation that we call vertical fiscal imbalance. The Commonwealth collects way more tax money than it needs, and the states were suddenly almost completely dependent on the Commonwealth to meet their financial needs. You might remember from earlier in this video that the Commonwealth also coordinated the states in terms of raising loans. So the Commonwealth had a bunch more money than it needed, and it also had the power to give that money to the states in the form of tied grants under Section 96 with whatever terms and conditions it felt like. This meant that the Commonwealth ended up sticking its nose into areas of policy where it had no business at all. Let me give you an example. Nothing in the Constitution gives the Commonwealth any business whatsoever in terms of primary or secondary education. And yet the Commonwealth has long given money to the states for the purpose of education, with strings attached. So, for instance, money might only be given to the states if they agree to spend it on teachers' wages or on certain programs such as the controversial school chaplaincy program. Around 2009-2010, the Commonwealth splashed out massive amounts of money on school halls as part of an economic stimulus plan. Why? Because it had heaps more money than it needed and heaps of power over how that money could be spent. This, of course, meant still further expansion of Commonwealth power at the expense of the states. The federation we have now, with a cashed-up Commonwealth enjoying expanded legislative power, is a million miles from the federation envisaged by those who wrote the Constitution in the first place. Is this a good thing or a bad thing? Well, if your favourite political party is in power in the Commonwealth, you probably think it's great. If you despise the current Commonwealth government, you probably think it's awful. But love it or hate it, that's the federation we now live in. A very strong Commonwealth government and states which need to come cap in hand, year in and year out, just in order to provide the basic services we all expect from them. Around the year 2000, it seemed like all of this might be about to change. When the Commonwealth government introduced the Goods and Services Tax to replace a range of previous Commonwealth taxes, the Commonwealth promised that all GST revenue would go to the states. The problem is this created problems of its own. First, there was the question of how the GST pie would be cut up. If a state contributed, say, half of GST revenues, should it get half the money back? Or should the more economically successful states take less so that the other states could take more? There is a bun fight each and every year about these sharing arrangements, and it's still the case that a large portion of the money given by the Commonwealth to the states is given in the form of tied grants with strings attached. Overall, you can see that the High Court's interpretation of powers under Section 51 has led to increases in Commonwealth power, and the end of the old implied immunities doctrine has led to more increases in Commonwealth power, and the Commonwealth's control over taxation and its ability to tie the hands of the states with respect to how that money has to be spent has led to still more increases in Commonwealth power. The intention of the founders to have strong states and a limited constitution has really not been all that successful. We're nearly there. The next thing I want to talk about is how the Constitution can be changed. Because while the founders did try to write a constitution which would be enduring, they were realistic enough to see that a process for amendments would be necessary. After all, the world changes. If you think about it, there are two questions we need to ask about any system for changing the Constitution. How are changes proposed, and how are those proposals decided? The rules for this are set out in Section 128 of the Constitution, which is long and detailed, but we can summarise it pretty easily. First up, in Australia, only the Commonwealth government can propose changes. This has always struck me as really odd. I mean, the states got together to do the deal which became the Constitution, but somehow they didn't give themselves the capacity to make any changes to the deal. In the USA, changes to the Constitution can be proposed by the Congress or by a convention of the states. Australia has no similar system. And as for the idea of actual citizens proposing changes, well, there's no capacity for that either. For a constitutional amendment to be proposed, it has to be supported by a majority of the House of Representatives and a majority of the Senate. Once a proposal is made, it gets put to the people for a vote in what they call a referendum. Basically, every voting citizen has to show up to a polling place, it's compulsory, and mark their ballot paper yes if they agree with the proposed change, or no if they don't. Those votes are then counted in a really interesting way. You see, to be passed, the proposal requires two types of majority. First, they count all the votes cast in all of Australia, including all the states and the territories. If there's not an overall majority, then the vote will fail. Second, there needs to be majority of support in a majority of states. So we have 6 states, a majority is half plus 1, half is 3 states, half plus 1 is 4 states. So in practice, we need not only an overall majority, but also a majority in at least 4 of the states. So let's say there was a proposal which was overwhelmingly supported by the 3 biggest states, New South Wales, Victoria and Queensland. and it was only slightly opposed in the three smaller states of Tasmania, South Australia and Western Australia. Well, that proposal would fail, because even though it would have the support of a majority of voters, it would fail to meet the required support by a majority of states. You can probably imagine that as a result, getting a referendum through all those hoops is quite difficult. And you'd be right. Since the time of Federation, there have been 44 referendum proposals put to the people, and just 8 have been successful. 3 of those came at the same time in 1977. Perhaps as a result, it has now been 19 years since our last referendum proposal, the referendum on Australia becoming a republic, which was held in 1999. Gosh, that makes it 20 years. Now, whether it's a good thing or a bad thing for the Constitution to be difficult to change is really a matter for personal views. On the one hand, if the Constitution is too difficult to change, then it'll become outdated. However, you don't want the Constitution to be too flexible, changing every 5 minutes instead of providing a steady basis for the law. All right, this is officially the last section, and to be honest, I've pretty much told you everything I need to tell you about what's in the Constitution. I want to talk for a moment now about what's not in the Constitution. Specifically, we don't have a Bill of Rights. Ever heard people carrying on about their constitutional rights? Well, guess what? We basically don't have any. Not constitutional rights, anyway. What do we mean by a right? Well, a right is something that an individual can assert against the majority. So, to take a terribly sad example from our American brothers and sisters, if you have a right to bear arms, then no parliament or legislature can pass laws to take that away from you, no matter how many people want gun control, no matter how many school children are slain in their classroom, no matter how much more likely a young African American person is to be shot compared to their white counterparts. No matter how tragic, it's a right. Nobody can take it away. In Australia, we don't have a Bill of Rights like that. We do have the rights that have come down to us from Magna Carta and centuries of common law, but even those can typically be legislated away by parliaments. We just trust the parliaments not to do it, and we stand ready to vote them into oblivion if they try it. So don't go looking for a Bill of Rights in the Australian Constitution. It's just not there. We do have just a couple of rights in the Constitution, though. The first of these is the right to a jury for any indictable crime under Commonwealth law. Now, this right is perhaps a little more limited than you're expecting. First up, it only applies to offences under Commonwealth law, whereas most criminal offences are under state law. Second, it only applies to what we call indictable offences. Now, without turning this into a criminal law lecture, we can broadly divide crimes into 2 types. Indictable offences, which tend to be the worst type, and summary offences, which tend to be the less serious type of crime. The only thing is there's no actual rule compelling the Parliament to make certain types of crime indictable. When creating a new offence, the Parliament can just do away with the right to a jury for that offence simply by declaring it not to be indictable. So it turns out the right to a jury is available only for a very limited range of offences, and it can be taken away by the Parliament. Not much of a right, really. Second, there's a rule that comes pretty close to giving us freedom of religion. The section is section 116, and it says, "The Commonwealth shall not make any law for establishing any religion or imposing any religious observance or for prohibiting the free exercise of any religion, and no religious test shall be required as a qualification for any office or public trust under the Commonwealth." Now that sounds straightforward enough, and to be honest, it's pretty good. There are really only 2 key controversies. The first is that obviously that rule doesn't bind the states. Second, the whole provision hangs on the meaning of the word religion. Now, at the time the Constitution was written, such a word would scarcely have needed definition. I mean, you were a Catholic or you were a Protestant. There was an awareness of religions such as Islam and Buddhism, but those religions were only present in Australia in trace amounts. There was no need in those days to ask whether Pentecostal evangelical churches constituted religion, or whether Scientology was a religion, or whether Wicca was a religion, or whether those who practiced the Jedi faith were practicing religion. In 1983, an action was brought by the Church of Scientology in Australia, and the court decided that while religion was impossible to define exhaustively, it had 2 characteristics: belief in a supernatural being, thing, or principle, and a code of behaviour or ethics or morals which are derived from that belief. So essentially, as long as your belief system has some commitment to the supernatural, your religion is potentially a religion. This leads to a really interesting question about the Commonwealth census. Now, the census these days has a reputation for disaster, and frankly, in my view, it's unethical that they link people's answers to their identities. But for some years, there's been a cheeky tendency by some people to record their religion as Jedi. And the Bureau of Statistics, in their dubious wisdom, have recorded those answers as no answer recorded. In other words, they've assumed that it was a joke. Well, the Jedi believe in the Force, which is supernatural. There's a code of behaviour attached to following the Force. It's difficult to see the Bureau of Statistics' decision as anything other than unconstitutional. The next one I want to talk about is probably our most important constitutional right. But strangely, it's a right that's not even written into the Constitution. Instead, it's a right implied by the Constitution and recognised by the High Court. We call this the implied right to free political communication. Now, this right was only recognised in 1992, although an earlier judge, Justice Lionel Murphy, had recognised this right in dissent in earlier cases. In 1992, there were two relevant cases, and I'll give you the references for both. First, there was Nationwide News and Willis, and then in the same year, there was Australian Capital Television and the Commonwealth. For the purpose of this lecture, we're going to focus on the Capital Television case, but if you're studying constitutional law, you'll want to check out both. Now, the Capital Television case focused on Commonwealth legislation whose purpose, or at least a key purpose, was to restrict political advertising on radio and television during elections, partly because some people found it irritating, but also because it had led to a bidding war for TV time and it gave the station owners quite a lot of political power. Now, the TV stations, of course, rather liked the revenue they got during election periods, so they challenged. And the High Court found that the Constitution as a whole is premised on the idea of democracy. It's a democratic constitution, and the whole document has to be read as supporting our democracy under the Crown. Democracy requires communication. The whole idea is that parties and candidates present themselves at election time and ask us to vote for them. Well, in the Australia of the 1990s, presenting yourself to the community meant running ads on TV. And this legislation sought to stop that at the most crucial time, during the last few days when studies show that most people decide their vote. The High Court essentially said this legislation undermines the democratic system established by the Constitution by getting in the way of free political communication. So they struck the legislation down. Talking about it now, more than a quarter of a century later, it can be hard to understand what a massive change this was. I mean, the very notion of individual Australians having a constitutional right of this type was groundbreaking. But the decision left a number of things unanswered. Could the freedom only be used to strike down Commonwealth legislation? Did it affect state legislation or people's private interactions? Just how much freedom could people demand? Well, all of this was developed in three subsequent cases called Lange and the Australian Broadcasting Corporation, Coleman and Power, and then summarised in McCloy and New South Wales. It turns out the right is pretty limited. It does potentially extend to both the common law and state law, but a law is only invalid if it prevents people from making a free and informed choice as electors. So it's not a general protection for political opinion. And laws can in fact restrict the expression of political opinion, for instance, by requiring political parties to declare who's funding them, provided they do it for a legitimate purpose, in a measured, restrained way. So the implied constitutional right doesn't privilege any particular arrangements for political debate, provided at the end of the day you still have elections in which voters can make free and informed choices. Your legislation is likely to be valid. Okay, one last right. It's actually not that important, except that it became the basis for the greatest High Court case that ever wasn't, the case of Kerrigan and the Commonwealth, in the wonderful Working Dog Productions movie, The Castle. I'm pretty sure it's now actually unlawful to practice law in Australia unless you've seen this movie and can give an adequate explanation of the vibe. In the movie, Darryl Kerrigan is trying to save his family home and those of his neighbours from resumption for the expansion of Melbourne Airport. And he ends up in the High Court where he relies on Section 5131, which gives the Commonwealth the power to make legislation for the acquisition of property on just terms from any state or person. The compensation offered by the Commonwealth was insufficient, and Darryl argued that on just terms would have to include the recognition of the value of his property as a family home full of love, not just a piece of real estate. Now, the usual wisdom is that in the real High Court, Darryl would have lost his case. In the movie, of course, he won, and the Commonwealth had to suffer in their jocks. What the High Court has said, however, is that just terms means just that. So, all circumstances would need to be taken into account. Personally, I think Darryl might have had a case after all. On that happy note, let's stop the clock. That's constitutional law, folks. Now listen, this is a complicated subject and I have stripped it back to its bare bones to try and help you make some sense of it. If you're studying this subject for uni, you've still got a lot of reading to do, but hopefully this will get you started. Now, I promise I'm going to try not to leave it for months and months this time before I put up the next 2-hour law course. And the consensus seems to be it should be something on criminal law, so that's going to be my intention. Please join the nearly 3,000 people now who've subscribed to my YouTube channel. And if you find these videos useful, please do think about clicking through to the advertisers who keep YouTube going. I know it's a pain that the ads come up in YouTube, but they are the ones funding it all, and it's certainly helpful to me if you click those buttons. Anyway, as the Bureau of Statistics most definitely does not say, may the force be with you all.